of you, and thank you for the time that you've all taken to attend today's meeting and to prepare and to send us reports. And we have some exciting presentations and proposals to share with you today, including some guest presenters that Dean Brown will be introducing, as well as some really exciting news for all of you. So let me first also thank Alex Gillette, who is now back with us from leave, and Lauren Orlowski, who, as you know, are not only amazing members of our commission, but they are our staff members. None of this could happen without them, and I am very grateful to them and for their assistance. They really keep this going, and so thank you to both of you for all your work. And as those of you know, this is just something they do as a second job because they have really high positions within the branch, very demanding positions. So I thank them for their time. I also want to thank all of you who have worked on the work groups and for your presentations, some of which you have received from Alex and Lauren in anticipation of our meeting today. I want to take this opportunity briefly, and you'll hear more from them directly, to welcome two new members. One is Attorney Cecil Thomas, who's the president of the Connecticut Bar Association and also is a staff attorney at Greater New Haven Legal Aid Services, and Attorney Jen Shukla, who he will introduce, and she will also speak to us momentarily. She is the Director of Access to Justice Initiatives, a new position created by the CBA under the leadership of Attorney Thomas, and we're so excited to welcome them as full members of our commission and to work with them. More on that in just a moment. I want to notify you that there are a few of our members could not make it today and have notified us. One is Judge Bright, who always attends our meetings. As you know, he's the chief judge of the appellate court, and pressing business on the appellate court has kept him from joining us today. Judge Mole, who is involved in the appellate pro bono work group, has also indicated that business at the AC has kept her from attending today's meeting. Judge Harmon will be joining us a little bit late. He had an emergency motion in his role as the presiding judge for Part A in New Haven. And I believe Judge Leo Diana is not able to join us because he is out of state. So with those absences, I just wanted to let you know that. Let me first then go to the first item of business on the agenda, which is the draft minutes of our July 13th meeting. I take it all of you not only received the draft, but have had a chance to review it. And so I will ask first for a motion to approve the minutes.
I'll make a motion. So moved.
Thank you. Second?
I was muted there, so I will second.
Thank you, Attorney Nelson. And any discussion? Let me first ask, are there any objections to the minutes? If there are, please raise your hand or speak up. Are there any? I see none. Are there any abstentions from the minutes? Can I just by confirmation ask, given the silence on both of those questions, do all members approve of the minutes? If you do not approve, please say so now. Thank you. The motion carries and the minutes of the meeting are approved. I will now ask welcome Attorney Thomas, who I briefly mentioned is the president of the Connecticut Bar Association. Under his tenure and leadership, he has created the position of Director of Access to Justice Initiatives, and Attorney Jen Shukla has been appointed and hired for that position. And I'd like to turn it over to Attorney Thomas to share a little bit about his role on the commission and the role of Attorney Shukla, and also turn it over to her. And I want to thank Attorney Thomas. He and I and Krista Hess, Judge Bizzuto, Ty Erickson, Lauren, and Alex had an opportunity to meet with him and Attorney Shukla, and we're super excited to have them on board. So Attorney Thomas, thank you.
Thank you, Justice Khan, and thank you for that very kind welcome. Thrilled to join this illustrious group, particularly under your leadership. I find myself as CBA president often saying a few words and then knowing when to get out of the way and set the stage for others these days. And so I will do that briefly and then turn it over to Attorney Shukla. So the CBA has, over the last several years, significantly expanded its pro bono volunteer opportunities, and those opportunities have ranged from opportunities that are designed for attorneys who have about half an hour or an hour of time, virtual offerings that are available in the community. Our Free Legal Answers program, which we serve as the administrator for locally in Connecticut, allows attorneys to participate in a online platform to answer questions submitted by members of the public who've been pre-screened in a variety of civil legal issues. Our Lawyers in the Libraries program, which is a creation of one of our prior presidential fellows, allows lawyers to engage with members of the public in half-an-hour consultations, offering free legal advice in libraries throughout the state. Our CBA virtual legal clinics, which we hold twice a year but are hoping to increase to a quarterly model this year, just recently concluded last week. It took place October 27th, 28th, and 29th, and we had 50 members of the public participate, 30 attorney volunteers and 30 law students who helped with the intake and referral process prior to those meetings with the attorneys and the member of the public. And Pro Bono Connect, which was developed in the height of the pandemic to provide virtual on-demand training for attorneys interested in providing limited scope or full representation in a variety of civil matters: housing, family, immigration. And so the scope and scale of our pro bono volunteer support programs has really increased, and it seemed appropriate to ensure that we had appropriate staff level support for those programs. And so that allowed us to create the Director of Access to Justice initiatives. In addition to our pro bono opportunities, we've obviously helped advance civil right to counsel measures in evictions and in domestic violence temporary restraining orders. And as consistent with our constitutional commitment, we look to advance opportunities to ensure the delivery of legal services to those who are most vulnerable and least able to afford it. And so thrilled to welcome on board Attorney Jen Shukla as our new Director of Access to Justice Initiatives. This is a full-time director level position at the CBA, so she answers directly to our Executive Director, Keith Ceresi. And she comes to us with a variety of experience. She is a graduate of UConn and Harvard Law School. Spent several years in practice in a variety of contexts, most recently in the family courts, where she was able to see firsthand the access to justice gap there. In addition, served as a leader in a variety of our programs, committees, and initiatives, including our ADR committee. So she comes to us with a wealth of experience, a wealth of enthusiasm for the work that she will do in helping us take our pro bono efforts and our access to justice efforts to the next level. So thrilled to turn things over to her and to welcome her as our new Director of Access to Justice Commission, or Director of Access to Justice Initiatives. And we're both thrilled to be part of this commission going forward.
Thank you, Attorney Thomas, for that very kind, very generous introduction. And also thank you, Justice Khan, for welcoming us to this commission. I am thrilled to be both on this commission and in this new role. I think it's just utterly fantastic that CBA has shown that level of commitment to create a new position to really focus entirely on pro bono projects and access to justice initiatives to help close that gap of people that need our legal services. I just want to say I've been a fan of this commission from afar, so I am familiar with a lot of the amazing work that's been done. I've read a lot of I think all of the minutes and the reports that have come out of this commission. I know Attorney Thomas spoke a bit about our various pro bono programs that the CBA is really focused on right now. I am getting involved in each of those, so I'm happy to provide more detail about any of those programs and how they work and how many attorneys we have volunteering with the various programs offline if anyone is interested in that information. One of the ones that I think is especially exciting is that free legal answers program. I know some of you on this commission were involved in getting that created and brought to Connecticut and establishing it here. So I did want to report that it is going well and going smoothly. We've actually had about 365 questions answered so far this year by a team of about 95 volunteers. So that's a good amount of legal information that's getting out there. And of course, we're going to work to continue to see that to grow and help even more people. As Attorney Thomas mentioned, we're also looking to expand our pro bono clinics and a lot of our other pro bono initiatives, as well as the more broad policy and access to justice parts. So I'm thrilled to be here, looking forward to being on this commission and getting to know each of you. Thank you.
Thank you, Attorney Shukla and Attorney Thomas. We are so excited. I, couldn't contain my excitement when we met earlier this week. I think you're a great addition to our commission. I think, as you said, you read all the minutes, so you know some of the terrific work groups that we have chaired by really and members, really talented members, and chaired by folks who are coming up with some terrific ideas. And we look forward to working with the CBA, and we really depend on each other. And so I think it's really terrific to have you on board. And we look forward to working with you. I can already think of many ways in which we can collaborate, including some of the proposals that you'll hear of at today's meeting. So we're going on to the next item on our agenda, which is updates from the work groups. I'm going to turn it over to Krista Hess, our Director of Court Operations. So she will cringe when I say this, but she is the guru of access to justice. She has been here from the start, helped create this commission, and it really knows it all in terms of what we've done over the last 10 years. I also want to thank her for taking the initiative. You may recall at our last meeting, we talked about having our work groups collaborate and work together on joint proposals. And I want to thank Krista Hess for taking the initiative to reach out to the General Pro Bono and the Moderate Means Working Group, as well as the Access to Justice and Libraries Group, and coordinating and working on a joint meeting. And so I'm going to turn it over to her. You have a report, but I ask her to give an overview and to call on the sub work groups as necessary. Thank you, Krista.
Great. Thank you, Justice Kahn. So the fact that I've been around a long time just means I'm old. So let's just keep that in proper context. So thank you. And I did send, and many of the other co-chairs are on this call, and please, I invite them to speak. They are far more the authority on all of this than me. So I would invite all of them who are at the meeting to speak. But we had a really good meeting back in August. It seems like a lifetime ago, with the Libraries Working Group and Modest Moderate Means and Pro Bono. We really talked about, how not to spin our wheels and how not to just, undermine one another or overlap, and how to leverage technology to make the most of our respective and collective efforts. And we had a nice discussion, and a couple of, I think, really substantive things came out of the discussion. Mostly it was what's next and where are we going next. But what we talked about at the meeting was, for example, the incubators, and about how that clientele sometimes does tend to be, not necessarily tech savvy, and technology can kind of present a barrier for them. And I think there's always those equally compelling schools of argument that technology furthers access to justice, but for some it's an enormous barrier. And knowing where that line is, and knowing and creating programs that reach both of those populations and LEP populations. So we talked about at the time, and Chris Nelson can certainly give you an update. At the time we met in August, the two incubator programs, the one at UConn, the one down in Bridgeport, were remote, and they were not actually seeing clients in person. So while technology was great because it allowed those attorney-client conferences to still occur, was wonderful. But for some, again, it was a barrier. The nice thing about that is it allows those those clients, those low bono clients, excuse me, who are with the incubators to not, to maximize that dollar that's going to that incubator attorney. You're not paying for the, time for that lawyer to go to court. And anyway, so it's a nice way to condense the session and maybe make it more advantageous for the client and equally advantageous for the lawyer. So we did talk about that. And we also talked, and then the other issue that kind of came up and I alluded to it was, the issue of technology being a barrier, and how our public libraries factor into that, and how they have phenomenal resources that are open at night and on the weekends, and how they further our overall access to justice cause. And Dawn, I'm going to put you on the spot because we had kind of an email discussion about what the libraries are doing, phenomenal technology advancements. And Dawn, I'll just ask if you could speak to that if you wouldn't mind.
Absolutely, and thank you. So public libraries in Connecticut were very fortunate to get we got a lot of money from the CARES Act and the American Rescue Plan Act that we put towards libraries expanding access. And one of the items that they're purchasing are study pods that they use for telehealth. But also that the libraries can use for confidential attorney-client meetings that are accessible and open. The other big project that we're doing, and Krista alluded to, is we've been working with the digital literacy gap for decades, and we're putting considerable resources towards digital navigators in the community. So not only will someone who needs technical assistance can go into the library and have a one-on-one session, have someone actually help them get set up, set them up in a small teleconference pod, but also our digital navigators go out and work in the community and work at the various organizations that we partner with. So lots of opportunities, and I think it's really libraries just expounding on the work that they've been doing for decades, and just beginning to expand that out with this additional assistance.
No, thank you. And we started the partnership with the libraries a number of years ago with under the Access to Justice Commission, and we could not be more pleased or more dependent, I might add, on them. And we educate one another, and I think we have oftentimes the same clientele. So to the extent we're able to work in lockstep with one another, and I think we are in terms of education and resources, I think it's working incredibly well. And Attorney Nelson, I'll put you on the spot if you want to add anything additional about our meeting. Oh, you're on mute, Chris.
Yep, I just keep doing that. Yes, I would like to add a few things. The first is to second Justice Khan's, glowing review of what Krista has done. Just coordinating this, joint meeting was a large task, and she has undertook that, put the report together and reported on it. And it just wouldn't have happened without her. So, thank you on behalf of our whole working group as well. And just as far as updates, as you saw in the report, one of the things that we discussed from the moderate means working group standpoint is this notion of limited scope appearances. And we'll plan on following up on that a bit more, but I think it's very important for us to try and get more detail about how these are being used. That way we can try and determine what we can do to increase participation. One of the problems that we have, again, as alluded to in the report, is the way documents are filed, cases are filed in the court. There's firm juris numbers, there's individual juris numbers, and that complicates things. So, but we're going to work on trying to do that. Aside from the report, but working off of that, One of the updates that I wanted to share with the group is it's somewhat anecdotal, but our working group just met the other day, virtually, of course, and since the summer, things have changed considerably for the incubators. And for those of you who are unaware, there are 2 incubators in the state of Connecticut. There is the Justice Legal Center, which operates out of the Center of Family Justice, or for Family Justice in Bridgeport, and there's the Connecticut Community Law Center, which operates out of UConn Law up in Hartford. Things have changed considerably for the attorneys participating in the incubator. A lot of things are going back to in-person. The overwhelming majority of work that the incubator attorneys have done, and I'm sure will continue to do, will come as no shock to the members of this body. It's largely family work. It's probably the area where we see the largest amount of self-represented people. There are certainly other large amounts, but that's probably the largest portion. One of the things we presented on last time was this notion of collaborative divorce. And it appears that we are, putting together groups of attorneys who want to do this work statewide, but we're lacking clients who are knowledgeable, who seek out this work. So one of the things that we want to do as a working group going forward is try and collaborate, to see where we can get information that would be, available to, self-represented parties going through, divorce. The clerk's office, the court service centers, certainly is something we're interested in. And then, the libraries, I think that's also, vitally important that we can get some of our materials about, the collaborative divorce process, out there. The other thing, and sorry, I got off track a little bit. I mentioned anecdotal information. Now that attorneys are appearing in court in person, from what we're seeing, at least initially, the costs to the parties who are being served by the incubator attorneys have gone up. What was a 30-minute video hearing is now potentially a several-hour hearing. Reports of 4 to 5 hours between travel and waiting in court for family relations and then waiting for a hearing. Nothing that's unexpected, I think, to members of this group. So that is a very significant cost to litigants by having the hearings back in person. Now, that only tells part of the story, of course. We don't know how much more effective those in-person hearings are. We, maybe things will be concluded faster. We also, want to make sure that the incubator attorneys who are handling these, cases on a reduced fee schedule are able to make enough money to be, profitable, fairly, so they can sustain a business representing, people of moderate or modest incomes. So that's important too. So we're going to continue to look at that. And then the last thing that I want to report is Jen Ferranti, who's on this video. She is the director of the Justice Legal Center. She can report on it as well if there's any other questions. But we have a good news, bad news situation. Right now, the Justice Legal Center has a pause in their incubator program. That, of course, is the mild bad news. But the good news is it's because the Center for Family Justice is undergoing a large expansion, and they are using up their available space. As Jen can certainly talk about if necessary, they do plan to be back with a full class for their next incubator class, which is a 2-year program, so it would be their 2023 class. But for right now, there's a little pause going on there. And Jen, if you want to add anything, you can, but otherwise, I think that concludes our group's report.
Oh, thanks, Chris. I'll just add, it's not a true pause in that we do still have one attorney and one alum on site who are providing services to our clients in the greater Bridgeport community. So we're just small right now, and we're not. We may even get a new attorney in January who is going to be primarily virtual, but it is certainly a much smaller version of our program to date, and we're looking forward to get back up and running in full in 2023. Thanks.
Sorry about that. Thank you.
And then I'll just quickly continue with pro bono, and I'll wrap up. So the other piece of the meeting from August was, and thank you, Chris and Jen, I appreciate that, and Dawn, was talking about pro bono. And as many of you have heard me talk, you know, it's something that I'm very passionate about, and the branch, I have to say, to our credit, is very much behind pro bono, generally, conceptually, programmatically, and we're very fortunate because of that. And the discussion at the August meeting was very much from the client side of things, how technology, how all of us can work together, whether it's, you know, the libraries, you know, all of the modest moderate means, pro bono, to help the client side of the delivery of services, and then also from the provider side, from the lawyer side of things. You know, how can we, what should our role be? And I say our, I mean the commission, you know, the legal community, our role be, and the administration of pro bono in Connecticut. And so it was, you know, a discussion that you might well imagine scratched barely the surface, but really did rely heavily on technology and on sort of that, as I talked about, that Match.com single point of entry, you know, having the attorneys register for, as you know, we've all talked about, whether it's limited or full appearances or family or online pro bono or clinics or whatever fits. And to me, the best model of pro bono is the model that fits that client at that particular time for that particular case, for their particular set of circumstances. And likewise for the lawyers, you know, how can we incentivize lawyers to do more pro bono? So it was a really good discussion. And at the end of the entire thing, you know, what I'm hoping our next steps will be is to set some sort of a prioritization list and go through, you know, what we'd like, what boxes we'd like to tick off, what goals we have as collectively, and just start to, you know, work through those tasks and really start to collaborate and make our way down the list of initiatives. I think there's a limitless number of things that we could do if all the work groups stay together and work together collectively. But I think we need to organize that. And I think this is a great group. I mean, the co-chairs are all very much, the buy-in is 300%, as you would imagine. So I look forward to doing this again, having another meeting and setting a prioritization list and starting to work through it and report out as appropriate.
Thank you, Krista. Thank you to our chairs of the various work groups. Again, I can't thank you enough, and I love the idea of the prioritization list. Having looked at the memo, the report that you prepared about this meeting, I could see, Attorney Thomas, you were listed in it as reaching out to you for looking at you know, enhancing the reporting and the pro bono initiatives. I know that's also high on your list, and Attorney Shuckless, so that's very exciting. And also the model in Florida, one attorney, one case, one per year, what an impact that would make. So I'm really excited to see, I think we're all excited to see what can come out of the work of these groups, work groups working together in the prioritization list. So thank you. And again, Krista, kudos to you and to all of our leaders for doing this. I want to call on Attorney Jeff Dowd, who co-chairs the Access to Justice and Libraries work group, along with Dawn Laval and Krista Hess, to report specifically on the individual work of that particular work group.
Thank you, Justice Khan. I just have two things. The first is the public service announcement. We were sort of in a holding pattern with that for a long time, but I've talked to Allison from External Affairs, and she confirms that they are recording again. So I'm very excited about that. I've spoken with Alex, and she has mentioned the project to her court service center staff and is waiting to hear back if any of them, that she has several that are multilingual, to see if they would be willing to do the recording. If that does fall through, we could always turn to interpreter services and have them do the recording for us as well. So that's the first thing. The second thing is the PSA, which is called Know Where to Start. It leads to a page, a Know Where to Start page, which will have several things on it. One will be a services matrix, which I've been working on. I presented it to the web board. They've made some good suggestions. So I've created several drafts of it. I think I'm nearing the final part of that. If any members of the commission would like to see the draft that I have, I'd be more than happy to send it to them by email. The web board also has said Vincent Cortese from Web Requests, he's starting to come up with a prototype page that would be mobile friendly, that would be able to contain the matrix. And he said it could be a little bit tricky, but he thinks he can do it. So I'll keep on top of that as well. But that's all we have to report at this time.
Thank you, Attorney Dowd. And in my role as co-chair of the Limited English Proficiency Committee, which is under the umbrella of Access to Justice, if you need any assistance with obtaining official, I recommend, obviously, we should use certified interpreters for the recordings. If you need assistance getting that, please let me know. And I'd be happy to look at a draft, but as well, when you have the time to send it to me, but let me know if I can help in getting those interpreter services. I know our IT staff are terrific. Alejandra Donna, as I'm sure you know, and her staff, I'm sure would be more than willing to help.
Well, thank you.
Next on, and again, thank you, Attorney Dowden, for your work group. I love all the initiatives you have. Our members, you should know, you have the full report of the work group. I encourage you to read through it and all the initiatives that they're currently working on and their status. I'm mindful of the time, and I want to be sure that we leave enough time for our guest speakers. And so bear with me. I will open it up for discussion or questions about any of these reports, but I want to be sensitive to making sure that the folks who are here to present to us have the time to all, give us their reports and their presentations. Next on our group is the work group on law schools. And first, I will ask Dean Ahmad from Yale and his co-chairs, Dean Brown and Dean Nelson. Dean Brown from Quinnipiac Law School and Dean Nelson from UConn Law School. They all co-chair the work group on law schools, and they have two presentations. Dean Ahmad has a very exciting proposal, and then after his proposal and any questions there may be, I do want to then turn it over to Alex Gillette for the introduction of Dean Brown and the presentation, very exciting presentation that we have. So Dean Ahmad, if you're still with us, if you or Dean Brown or Dean Nelson wish to report on your proposal.
Thank you, Justice Khan. I appreciate the opportunity to share some of the work that we've done, and so I'm going to do this on behalf of Dean Nelson and Dean Brown, and invite them to add or correct just after a brief presentation. So, as we set out in our brief written report, we are proposing to do 2 webinars in the spring of 2022 that will focus on the recent expansions in access to justice in Connecticut. These are items that Cecil alluded to earlier with regard to the right to counsel in eviction cases, as well as the grant program for the provision of lawyers to people in need of a restraining order against a violent partner. And our thinking here was that the law schools are all already engaged in a variety of different types of civil legal services through our clinics and externships and internships that our students do during the summer. But we saw here an important opportunity to both for the law school communities as well as for the larger legal communities of Connecticut to shine a spotlight on these recent important developments in and expansions in access to justice. So we really see this as an opportunity to educate the Connecticut legal community about each of these programs, to look at what the early steps of implementation are. These obviously will take some time to be stood up as programs. And so the hope is that we'll, by that time, have at least some anecdotal information about how that process is going. That may create some opportunities to also identify areas for improvement. Third, we wanted to take these important developments at the state level and place them into a broader context, both nationally and just in the history of the state of Connecticut as part of the Civil Gideon and universal representation movements that we think would be important for students and practitioners alike to understand. And then last is to be a little bit forward-looking and thinking about what we might be able to learn from these programs that might suggest future direction for expansion of access to counsel in Connecticut. We gave some thought to whether we would do these in person or online, and the combination of the ongoing restrictions at our various campuses because of the pandemic, as well as our interest in wanting to make the programs as widely available as possible to practitioners across the state, led us to conclude it'd be better to do this as a webinar rather than in person. As we note in our proposal, our thinking is to have a mix of speakers. So to have key legislators who were involved in enactment or the drafting and enactment of the legislation, directly affected individuals, service providers, as well as faculty from our respective schools who could provide some of the historical or contextual information about the access to justice movement. I think the last thing I'll say is that we see this as a good, important opportunity for our three law schools, which all have very congenial relationships, to do something that is joint, which I think doesn't happen that frequently. So it seemed like a nice opportunity to do that, and hopefully to do that as a project of the Access to Justice Commission. I want to say, the leadership that Cecil has already shown at the CBA on access to justice, as exemplified by the hiring of Jen, makes me think that, and I'm sorry, I haven't vetted this with my co-chairs, but makes me think that we should think about asking the CBA to co-sponsor the event and think about this something that we could plan jointly. So I'll stop there and see if Dean Nelson or Dean Brown want to add anything to that.
Thank you so much, Munir, for giving that report on our behalf. The only thing that I would add, I think another goal and one of the reasons why we thought it would be good to go virtual is hopefully we would get participation from people outside of the state, and so that they can also learn about these types of very incredible initiatives that they may think about implementing in their own states to help further access to justice. So that was another advantage we thought of having it virtually.
So I want to thank Dean Ahmad, Dean Nelson, Dean Brown. I was super excited when you shared this proposal, and I'll try to contain myself because I was teased a little bit when I met with Attorney Thomas and Attorney Shukla about their addition to our commission. I think it's a terrific idea. I don't want to speak for Attorney Thomas or Attorney Shukla, but I can speak for the Access to Justice Commission and share with you that Judge Bizzuto, Ty Erickson, Krista, Lauren, Alex, we were all super excited about this. You can certainly count on my help and my assistance and our commission's participation and assistance to the full extent that we can. Sometimes we have some limitations, on when we put on our judicial branch hat, but I don't see any in this area. And I think these are terrific webinars, and I stand ready to help and support in any way I can. And encourage you to go forward and do this. And to your point, Attorney Dean Nelson, as far as it being a model for other states, I think that's terrific. And once these webinars happen, in my role on the national as chair of the Access to Justice Commission, and in my role on the national level, I certainly would promote it and maybe suggest that you, the deans, present this. They're always looking for ways in which law schools can be part of the process of expanding access to justice. And I think it'd be terrific to have the law schools present at a national meeting of the Access to Justice. And I don't want to have a spoiler alert. There's more to come on the national level that's very exciting. So I thank you, the deans, for this proposal. And if anyone has any questions, very briefly, before we get to the next presentation, because this is a new proposal, please let us know. I see Attorney Thomas is clapping, so I applaud that and second that.
Thank you, Jessica. That was me actually raising my hand, but I would applaud as well. But thank you. I would just say on behalf of the CBA, again, we were heavily involved in the Civil Rights Council advancements in the last legislative session, and hearkening back to the work that many of us were involved in the 2016 affectionately nicknamed Civil Gideon Task Force report. And so would be thrilled to partner with all of you at the law schools in promoting and producing these webinars.
Thank you, Attorney Thomas. Thank you, Dean Ahmad, Dean Nelson, Dean Brown. I'm now going to turn it over to Alex Gillette. And let me preface this by saying we are so honored and pleased and grateful for the work that Alex and Lauren do. Attorney Gillette, Alex Gillette, is a proud alum of Quinnipiac Law School and is familiar with the substance of the next presentation. And I thought it fitting to give her the opportunity to introduce Dean Brown and our guest presenters. And I thank them, and I thank you, Dean Brown, for this presentation as well. Alex?
Thank you so much, Justice Kahn. Thank you for giving me the opportunity as well to introduce Dean Brown, who is, as you mentioned, the dean of my law school and also somewhat a bit of a mentor to me. So Dean Brown, hello. I just wanted to talk a little bit about this program very, very briefly to be able to share this really exciting update on a program that's based in the law school that's also helping to reduce homelessness through mediation and the funding available through Unite CT and the Department of Housing. So I'm not going to go into the details. I'll allow our two speakers, Brendan Holt and Berta Holmes, to do that. But without further introduction, I'll pass it on to Dean Brown. Thank you.
Thank you, Alex. We are so proud to call you one of ours. So thank you very much for those remarks. I do want to give the time to Brendan and to Berta to speak, but I think it's really wonderful for them to be joining us. Chris Nelson kind of gave us the call back to the earlier discussions of collaborative lawyering, and I think this is of a piece with that we should be thinking about access to justice as something that is happening inside the courthouse, certainly, but also through some of these initiatives. It's happening outside the courthouse, and I'm very happy that Quinnipiac has been able to be a place where through this Connecticut Department of Housing grant and through collaboration between the Quinnipiac Center on Dispute Resolution and our clinical legal education program, we've been able to have this homelessness mitigation mediation project. And Brendan Holt, a Quinnipiac alum, a very experienced mediator, serves as the executive director of this program. Berta Holmes, also quite experienced in working with Community Mediation, Inc., as well as other community organizing efforts, works as our associate director of the program, the Homelessness mitigation mediation project. So at this point, I want to turn it over to Brendan and Berta with my thanks for their time and efforts and the good work they do. Thanks.
Thanks, Dean Brown, and thanks to everybody for allowing us to be part of this and kind of listen in, see the good work you guys are all doing, and just contribute a little bit to the conversation. So, when we're talking to students about this process of access to justice and an alternative approach, ADR approach to helping folks with legal problems, I always try to remind them, that it's so important to not take too narrow a view. And when you're so focused and in the weeds in a particular area, it's easy to do for all of us. So I think what I've had the benefit as a neutral in my career of understanding is there's procedural mechanisms and there's, legal justice, and then there's the concept of justice that people come up with, on their own sometimes. Restorative justice practices, the idea of reconciling within a community, victim offender dialogue. This is the first type of mediation I did right out of law school. So this program is really an opportunity to kind of showcase that and try to make it real in the community again. And it's been an honor to try to kind of get that going and introduce it in terms of a time of such need. And it's been amazing because Berta has worked in that community, in particular with housing, in a number of different capacities for 25 years. So it wasn't quite as in the spotlight before COVID made this an even more severe issue than it already was and will be post-COVID. So it's just been amazing to learn from her and those experiences. And that is what we're all learning together. The program is a lot of great efforts going in, and I don't know that we all knew it at the time, the Department of Housing and our organization providing the mediation and the initial framework, but we kind of have started and set up a program that is actually now been kind of showed by some research that was done by the Harvard Negotiation Clinic in partnership with the ABA to really be closely aligned with what they're finding are best practices. They did some amazing research about ways to approach this problem. From some organizations in different states that have been doing it even pre-COVID, and even the ones that are successfully doing it in the COVID era. And what we're creating with our other partners aligns with that model. They call it basically an idea of a three-legged stool where there's social services, legal services, and mediation. And that's legal services both tenants and also landlords, and mediation. And also the third leg being government agencies and funding bodies. And when you kind of bring these three different areas of expertise to bear on an issue and function as a team, that was where really the research showed the greatest results. And the programs that seem to be the most robust, particularly the ones that had existed with COVID, before COVID. And so what they kind of indicated was, I think 70% of the landlords that they talked to were interested and inclined to address some of these issues of non-payment outside of the court system. And I think, some folks might be a little cynical at times about, well, maybe that's because they didn't want to go and have all those legal rights of the tenants respected. But what was also linked to that 70% approval rate of doing things outside the court system if possible was the preference for it went up if the tenants were also represented by legal counsel. So it was not necessarily out of a kind of trying to game the system and no representation for those folks. We can just win on the outside. They just realized that agreements can be more robust where everybody comes into a mediation well-informed and represented, and good agreements can be drafted and they will be sustaining. So, there is that willingness of people to work outside the system in a safe way and in a way where they're represented and their needs and legal rights are met. So that's what we're trying to coordinate now. And again, it's been an unprecedented problem, a team brought together in a really unique way under high pressure. So that's some of the growing pains of the program too. How do these three legs of the stool come together? Who are the other stakeholders that we need to communicate with? And so we're all kind of simultaneously building our own teams and learning to communicate with the other teams about how we can backstop one another, and where we can do better work and where we need different communication levels from different partners. And that's been the ongoing process. And, some folks are kind of, upset when things change, but this is a program that has to. We learn every day about something that could be done better or a gap in the system that we can plug and redo and reinvent. And so that's been a great challenge, but also pretty rewarding when we get it right and connect with these folks. So there has been now, in our work, not with the ABA research with Harvard, but anecdotally, we're seeing the same things. Ideally, we are trying to do our work with folks as early as possible. And I look at this as kind of the top of the funnel. And this is, when we're talking about procedural justice in the court system, in no way does it minimize it in my mind that things like ADR should be early, like preventative medicine. I was raised in a family of chiropractors. I can't help but think of it this way. There's certain things you can do to stay healthy, and you can do a lot to stay healthy, and you can intercept things that aren't necessarily acute enough to need a trial or a legal case at that moment, although there are illegal issues involved often. And then when that doesn't work, there is the rest of the system. There is critical care, there's surgeons, there is modern medicine. It's not exclusive to the other. But what we're finding in this program is that it is very tricky to get early access to these issues. This is a program that's new, and this is a problem that is not. And we're building it as the eviction crisis was developing. So there are people who've been in the queue of this program for quite some time. And despite best efforts, and now that they are moving through it, by the time they get to mediation, often they have been waiting for their access to justice for a long time, landlords included. And so this program really aims to serve both. There are landlords that don't own hundreds of millions of dollars worth of property always. They're often paying their mortgage with the money that they get from the rent that they collect. And these folks are suffering as badly as the tenants in some cases. So the unique piece of being a mediator is getting to see all these different issues come to bear and finding out there really can be common goals. And it's frustrating when it gets to us too late, when this, addressed 3 months ago or 4 months ago, or at the beginning of non-payment could have been something we helped them with, particularly where the issues surrounded things about communication breakdowns, relationships that they want to preserve, stability that they still want in their tenants. These have years-long relationships in some cases. And sometimes those bridges are kind of burned by the time we see it currently, but not always. So that is kind of one of my big messages is partnering with all of the stakeholders here to understand that I think ADR is at its best sometimes in the beginning and sometimes outside the system. And I speak to this from experience as a former family relations counselor, where I was one of the in-house mediators. And I have amazing colleagues who still work there. And it was kind of a formative part of my career to work with mental health practitioners as much as lawyers and learn how to kind of apply certain legal principles and ADR principles in the context of human psychology and human behavior, and realize that in the system is ideal and necessary, but it also puts a lot of pressure on folks. It's a whole separate set of headwinds and anxiety and extra issues and tension that don't have to exist if you can somehow help these folks earlier, particularly when they're still being met with legal advice and given some counsel and know they have access to the system if it breaks down. So they really bring their best selves to the process, knowing it doesn't have to be resolved. They can be empowered to resolve it if they want to, and avail themselves of the branch if they need to or are unsure. So that has kind of been our experience of this. And if Bert has any comments you'd like to make about particular cases we're seeing, or maybe we could just turn it over for questions, and then she and I could answer anything you might wonder about the program and what we're seeing so far.
I would ask Attorney Holmes if she wants to add anything, and then I'll ask Alex if she would kindly lead the Q&A. How exciting and wonderful to address these issues before they have to get to the courthouse steps, and when often they can be resolved in advance. So thank you. But I'm going to turn it over to you, Alex, okay, if you don't mind to run the Q&A, and then I'll get back on. Thanks.
Sure, I'd be happy to. Dean Brown?
Thank you, Alex. So I guess I have a question both for Brendan and for Berta, and it's really twofold. It's sort of about the future of the work that you're doing. You're grant funded, but how long will that last? I think it may be helpful for the commission to know about that. And perhaps a related question is, given that this commission exists to try to promote justice in this access to justice in the state of Connecticut, and you have folks on this commission with relationships and opportunities to have conversations that may be helpful. what, if anything, could the commission and particularly the judicial branch do perhaps to kind of support and reinforce these efforts outside of the court system?
Yeah, as to the funding piece, this is a time-sensitive issue, obviously. So it's really federally backed money through the Department of Housing. So right now it's limited to COVID specific. If they don't qualify for Unite CT, we can't mediate with them. So they have to go through that system, be vetted through that system, approved in that system, which often obviously means that they are kind of pretty far along in the crisis. It's not early. That funding has come in kind of two waves. We had a 6-month pilot program where we were doing the work, and then when Unite CT came online, that began our second 6-month program, which we're in now, with tweaks to the objectives, tweaks to the details, which that 6 month will actually end at the end of December. So January 1 officially, there is not a guarantee of the program. I'm just beginning to kind of start to have those conversations about where we might fit in and what retooling needs to be done or what has worked. So really there's a lot of question marks about whether it will go beyond December, at least the mediation component. Unite CT obviously has much more work to do and will be around beyond that. So we're trying to find that out. But as of now, I kind of have to assume there's no guarantees beyond the start of the new year. And the idea of what other partners could be involved or what other resources brought to bear. Again, I mentioned my first job ever as a mediator with the Dispute Settlement Center, doing in-court victim offender dialogue in Waterbury and Bridgeport courthouses. I think they were unfortunately a victim of the financial crisis in 2008. I had left at the time, but I think when the budget was in really, really bad shape, some of those community programs lost their funding. That program was shut down, and it kind of started a little bit of a death spiral, unfortunately, for community mediation across the entire state, which it's ironically how we were found by the Department of Housing. There aren't any other community mediation organizations to reach out to. When they kind of looked at the early research that now is more robust that we have, I think they said, oh, what is really mediation? Where would that fit in? Who mediates in Connecticut that we could avail ourselves of? And there's no organization really left that does it at a large scale. So that's the partnership we developed to try to kind of provide that service again. So yeah, I hope this is some kind of springboard to bring that back. The branches had those relationships in the past where outside mediators alleviated and took some of the load off of the mediators in the branch. I remember what it was like, and it could not have gotten better in COVID and family relations and the housing mediators in particular. The idea of appropriately understanding what cases could be done before, outside in partnership and understanding with the role of the folks on the inside, that's a possibility. So I don't know what other organizations can, and I know, budgetary issues are always what they are, but I know there was that past relationship. And the new one with the DOH is fantastic. So that's an organization I had no contact with before, no knowledge of really before. But I think if we all realize, and this is, again, being unique to the middle in these conflicts so often, seeing all the different perspectives and stakeholders and all the challenges, we really can all complement each other. It's certainly not a competition to help folks. It's often not even a competition between the landlords and tenants. They both want stability. They both need some kind of resolution. So, and any of those stakeholders who think that they serve this population in some way, I imagine there's some way mediation could alleviate part of the strain you're all under in each of your different organizations.
Thanks, Brendan. Do we have other questions?
Can I just jump in real quickly, Alex, if you don't mind?
Absolutely.
Thank you. So, Brendan, thank you so much for your presentation and the work you're doing. It really sounds exciting and has like so much potential. And I may have missed this because I'm going in and out of meetings, but how is it that someone, whether it be landlord or tenant, connects with the program? Like, how do they find you?
Yeah, through Unite CT, and that starts pretty much as kind of a website-driven process. In the early goings, before it was Unite CT in name, it was through 211. 211 would kind of refer people and screen it. Unite CT now is a much bigger program, and so they find it through the website, and there's a level of auditors auditing whether they meet certain basic criteria. After the auditors, it goes to a different type of case screening, and then it goes on a third level to eviction prevention specialists. Who kind of have a little screen we helped provide to try to guess if it's appropriate for mediation versus legal services or both, or to the homelessness prevention staff that's been around for decades doing this work. So then they kind of triage as to which service would be most appropriate given the circumstances. So we are, I guess that's about 4 layers down before mediation is introduced as a possibility, at least in the current structure. So they kind of funnel it through.
So and are you guys the only organization that's doing this community-based mediation, or do they have a number of other providers around the state?
We are the only ones at this time. Yep. I mean, because again, community-based, correct? Because there's the housing mediators who clearly are doing it every day.
Right. Well, that's obviously, you guys are all walking to the courthouse door, right?
Well, occasionally a case will be continued and they will be sent out because they're not sure what's happening with Unite CT, but that's been a rarity so far. So yes, typically prior.
And do you have any idea of how long it takes to get through those 4 layers of vetting before it gets to you? You know, from the contact with Unite CT and it ultimately gets to you?
Yeah, I mean, Berta might be able to speak more. I don't know. It's not exactly one, but it's often months. Or it was. I mean, things are starting to get a little more efficient as things develop, but in the beginning, in the early going, it was quite a long time.
We are actually getting cases. Sometimes the person has already had an execution and Unite CT is not even aware of it.
Okay. Huh.
But I think it would be ideal if we have relationships with attorneys from the beginning. The moment that your client said, I want to evict this person, that they can refer them to mediation, because I think people have a tendency to forget that landlords and tenants have a relationship. It's a business transaction, but it's still a relationship. And if we can preserve that earlier instead of later, by the time we get the cases, they're angry. It's been months since they've communicated with each other. Maybe we could salvage the relationship. And if not, if the landlord wants the tenancy to end, at least help the person to have an exit plan with a dignified move out.
Do you guys do any advertising?
Only through Unite CT right now.
Unite CT provide any advertising for you to, you know, let people know this resource is available? I guess not from what Bert, I see Bert, you're shaking your head. No, and I take it, it can't come directly to you. It has to go through Unite CT to get to you?
Yes, because right now they're the only funding source right now.
But they wouldn't permit someone, you know, hearing about you, directly reaching out, saying, could you help us?
No, because we wouldn't know for sure then that they are actually qualifying for Unite CT, and the nature of this funding source, if they're not screened as COVID affected or COVID related, it's not a Unite CT case, then it would never get to us then. And we'd have to kind of push it back up the chain to say, could you vet this case and qualify it and run it through the auditors?
It sounds like such a great model. And Brendan, I couldn't agree with you more that there's the potential for so many better solutions by way of, ADR or before they're in the morass of a court process, right? Where sometimes it inflames people and makes them even more divergent than before the action was filed. So it sounds like such a great model for success. But thank you.
No problem. I mean, we've had also some wonderful experiences in the middle recently with statewide legal services, which is one of the triage services, trying to find out when they come to you, and mediation might help you and them, could you kind of cross-refer? And when they come to us with a clear need for representation, can we find a way to get to you? So we're finding our way to work with legal services under the current model. It's just, again, as we go, we learn.
And, and courts have their places in society with evictions, but if we can preserve that relationship with the landlord and the tenant, because once it makes it to make the case goes to court, to get another apartment, once you have been served an eviction, once you can see it on the Connecticut judicial website, they virtually do not have any other alternatives for decent housing.
Right.
Speaking as a former housing mediator, this is sort of music to my ears. This is exactly the sort of program that you want to see out there that exists for those landlords and tenants who have the ability to preserve a relationship, who may have just had sort of a bump in the road, and have the ability to get back on track and continue a long-term tenancy. This is a really interesting program. Krista, you looked like you had your hand raised for a minute.
I did, but Berta very eloquently said what I was going to say, which is if we can have people avoid a judgment on their record, and particularly when their housing became what it was through no fault of their own, or regardless, really. To be able to avoid that judgment on your record to get future housing is huge. And Bert, I couldn't agree with you more. So it's a great, great program, Brendan. Thank you.
Sure. Thank you. Thanks for having us. Really appreciate it. And thank you, Berta, for helping us through it.
Great. Thank you very much. Pass it back to Justice Khan.
Thank you. Thank you, Alex. Thank you, attorneys Holmes and Holt and Dean Brown. This is really, really exciting. And I can tell you from the national perspective what the Access to Justice Commissions and the Access to Justice for the ABA, and soon you'll hear about some of the initiatives with the Department of Justice. They're all focused on thinking outside the box, and that access to justice doesn't just begin at the courthouse doors, but actually we should be thinking about ways in which we can help people to prevent them from needing to go to the courthouse. That is why our work groups like our Access to Justice and Libraries and our partners outside of the courthouse steps really matter. So thank you for this great work that you're doing. If you don't mind, I will share that I'm sure they know, but on the national front, they always want to know how the funding and how these programs make an impact on the ground. I see Attorney Holmes, you had your hand up, so please.
I wanted to point out I'm not an attorney.
Oh, well, I'm not always sure, and that may be an asset. No, apologies to all of us who are attorneys, but I think that's terrific. And I guess, again, Access to Justice is looking at ways to provide access by folks who are not attorneys. So that is definitely not, that's an asset, I think. Sorry, those of us who are lawyers, sometimes we just get in the way instead of resolving things. So thank you again for your great work. Thank you, Dean Brown. I don't know if there's anything you would like to add, Dean Brown.
No, I don't think so. I do think, though, that when the pilot is, well, we've already finished the pilot, perhaps as December rolls around, it could be very useful for Brendan and for Berta, to just really reflect on what made the program work and perhaps what some of the obstacles were in those cases where agreement was hard to achieve. What were the incentives or lack of incentives that made that so? And then again, for us to think from the Commission's perspective, is there anything that the court system could be doing that would shift some of those incentives when people are able to get into mediation earlier on? Would landlords perhaps feel more comfortable agreeing to a settlement, knowing that if it falls through, the court system remains an option to them, and that it might even be fast-tracked or something, that really gives them relief quickly, so they don't feel that they've lost a remedy by agreeing to things in mediation. I think we all know that they don't, but I could imagine that there are concerns for those participants. So that's just a suggestion. I hope that Brendan and Berta will continue the great work and thinking about how their program fits into this larger context. And thank you, both of you, so much. And thank you for working with our Quinnipiac students as well. We're very grateful.
Welcome.
Yes, I would echo those sentiments, and thank you for your terrific work. And I do think it would be appropriate to have you return and report on your findings as a result of the pilot program. In my role as chair of the commission, I think that's really important for us to have that discussion, Dean Brown. I completely agree. I cannot speak for the branch. I defer to Judge Bizzuto, Ty, who's not with us today, but Krista Hess and others for what we can do as a branch, in court operations. But I am sure that Judge Bizzuto, I don't want to speak for you, but I would imagine you would be interested in knowing those, getting that feedback.
Yes, yeah, absolutely. Very much interested. So we look forward to future conversations for sure. Please.
Great. Thank you, everyone. Really appreciate the time.
Thank you.
Thank you. Thank you, Dean Brown. Thank you both so much. We look forward to hearing more from you and for your great work and the impact that you're having. And again, I'll speak with Dean Brown about the ability to report on something like this at the national level, obviously from your perspective, as well as to the law school work group. Let's get these webinars going and also having you report on those. So thank you all so much. So I want to talk about National Access to Justice Commission meeting and then other business and new items that we need to cover. First, some of you on the commission have already received the invitation to attend the National Meeting of State Access to Justice Commission chairs. It's usually held at the end of the week or the 3 or 4 day program on access to justice and equal justice that's hosted by the American Bar Association, often attended by many legal aid service providers around the country. This year, we are separating the two, but the meeting, although the meeting of the chairs of access to justice is private, all of the educational programs are available to all commission members and at a reduced rate. So I believe the rate is $75 for commission members, but if you work for the government or if you're in academics, I think it's even less. It's $50 to participate. And I just wanted to encourage all of you to consider registering and attending, at least look at the agenda and attend the programs that are of interest and that you would find useful. I want to just highlight a couple. I am actually on the commission. I am one of 8 people on the national committee that's putting together the agenda and the curriculum for our annual meeting. Connecticut, we typically report and run some of the either table talks or discussion sessions. And so I was honored to be asked to be part of the group that generated the list of topics to be covered. I want to thank Judge Bizzuto and Krista Hess, who particularly assisted me when all the proposals came out about what things we should cover. They were instrumental in helping me sort of prioritize from our perspective, from our Connecticut Access to Justice, what might be important. And so I thank them. Just by way of giving you a little bit of a highlight, there will be counsel to the Office of the Attorney General, Margaret Goodlander, will be one of the keynote speakers, and I'm going to talk to you a little bit about a national initiative that's happening. Judge Yang of Los Angeles Superior Court, who's the chair of the Standing Committee on Legal Aid and Indigent Defense, will be giving a presentation. The president of the American Bar Association will be speaking, and then they have keynote speakers, including issues on emerging issues in access to justice during COVID and beyond, talking about the legal services continuum and how we can provide services beyond traditional models, pro bono needs and private bar involvement, how we can enhance that. So that, Attorney Shukla, that would be very much of interest to you. Self-represented litigants and emerging issues in that field. Programs like the mediation homelessness program will be the kinds of things that they're looking to do, thinking outside the box, how to involve law schools. The format will include some keynote speakers and then breakout sessions, and then there are a series of table talks, and you can pick between them. They will be repeated, so if you have 2 table talks that are happening simultaneous and you want to participate, you'll be able to sort of pick and choose, divide and conquer, which is usually what I do with my co-chair at these meetings. We will have sessions on using data and coalition building to drive debt and eviction lawsuit reforms. This would be very interesting to Dean Brown and to Ms. Holmes, and so those of you who are doing this work. Help me help you, convincing people to invest in the work of access to justice commissions. How can we improve our funding and our participation? eviction diversion programs during COVID, potential approaches to handling the crisis, unbreakable commitments, building accountable relationships with continuing communities experiencing poverty and racism. Racial justice is also a key piece of our programming and how that overlaps with access to justice. Housing justice and racial justice. What we know, what we don't know, and what happens. Remote technologies. Krista, this will be incredibly useful to your remote access work group. Justice for all, how it works, how strategic planning can provide a framework for the unexpected, and how the unexpected can focus strategic planning. So what have we learned from COVID? How can we prepare for the unexpected? And what kind of strategic planning do we do around that? One of my favorites, courts as a service, not a place, lessons from COVID. Understanding the justice needs in our area. How do we really learn about the justice needs in our area? How can we best do that? Again, with speakers from both the Department of Justice and other programs around the country. Leveraging technology to advance court efficiency, equity, and openness, and access to self-represented litigants. Judges in lawyerless courts. Help everyone needs pro bono assistance, how we can improve pro bono assistance. These are just some of the programs that will be offered. And so I really encourage you, if you can, it's December 2nd and 3rd. Look at the agenda, it's virtual, so you can pick and choose, and it's relatively inexpensive. So it's a great way to participate. I've been trying to get members of our Access to Justice Commission to go, especially our staff members and like folks like Krista Hess, and we never could get funding, and the judicial branch never had a funding to provide for that, and the scholarships are very limited. So this is our opportunity to attend, and I encourage you to do so. I want to go on to the next, and if anyone has any questions, please feel free to email us. If you did not get the email to register, please let us know. Students, by the way, are also invited. Deans of the law schools, students are invited to attend, and they get a special rate, I think, of $25. And I do have students both at UConn and Quinnipiac that have expressed interest in access to justice. So if you want to take a look, let me know. Going on to other business and new items, I do want to turn it over to Judge Bizzuto and Krista Hess, who are going to give us some updates on the judicial branch. But before I do that, I want to tell you some exciting news on the national front. On the national front, and I will be asking Lauren and Alex to send you these emails so that you will have access to them. I'm very excited to report that the U.S. Attorney Merrick Garland announced, some of you may know this, the restoration of the standalone Office for Access to Justice. So 10 years ago, under President Obama, there was a standalone Office of Access to Justice that was created. They were very active in access to justice initiatives in our national meeting. I've been a co-chair since 2010 or 11, and was, remember the days when the Department of Justice was very active. That office was created by Attorney General Eric Holder, but in 2008 it was closed, and some of its tasks were assigned to the Office of Legal Policy. Well, it's now been reinstated and created by the current administration. So that's very exciting. One of the announcements in the restoration of this office was that access to justice today may require different tool and initiatives and a different office structure than it did a decade ago. So there have been reports around how this office is going to be restored. It works very closely with access to justice commissions around the country and under the ABA access to justice umbrella. So first, is the creation of this office. Second is that there was a report issued by the Attorney General, and it was a report to President Biden relating to the Department of Justice's access to justice function and restoring that function. And really, two things came out of that report. One is that there was an extensive 120-day stakeholder review. So the Department of Justice reached out to all the stakeholders. And what they found was that there were significant gaps in equal access to justice. And it revealed significant inequities that have become exacerbated by COVID. And so there's a real need. Not only is there a gap in access to justice and inequities, but they've been worsened by COVID. And so the Department of Justice will launch a phased-in strategic plan to restore and expand its access to justice function. And so that's really important. And there's a report that talks about that. I don't have time to go over it in detail, and they did it far better than I can in paraphrasing it to you, but I encourage you to look at it. There will be a link in the email to it. In addition to the strategic plan and to the findings of this extensive review, there used to be a roundtable, a legal aid interagency roundtable there under the previous administration. That too has been restored. And there has been a new report issued, a September 2021 report of a new roundtable on access to justice in the age of COVID-19. It's a wonderful report. I encourage you to review it as well. I did. Basically, they brought together 28 federal agencies, and they talked about the impact of the pandemic on access to their programs, their initiatives, and services across federal government, and came up with recommendations. The report describes key lessons that we have learned in creative innovations that may help expand access to government programs more broadly. So the roundtable will continue to collaborate with these federal agencies, and we expect that they will have further interagency reports and collaborative programs. I think it's very important for us as a commission to watch them closely and to see the results of these reports and where they identify areas going forward. I can tell you from 10 years ago, limited English proficiency was a huge deal. I anticipate that will come up again. So that's just one area of my own personal experience that I can see there being a focus on. So we will send you these emails so that if you have not received them or heard of these federal initiatives and the Department of Justice's involvement, that you will have access to these reports. And I encourage you to read them. I think it's wonderful to have the Department of Justice very actively supporting access to justice at the national level. Often it also means funding for programs like the program at Quinnipiac and other programs. So more to come on that. I'm going to turn it over to Judge Bizzuto, our Deputy Chief Court Administrator, and Krista Hess for an update from the judicial branch.
Krista, I'm going to let you do the items that, to update, if you don't mind.
Sure. No, I don't mind. They're doing work on our parking lot. So if you start to hear all sorts of, I apologize. But no, thank you. I'm going to quickly just give an update on some of the initiatives that we report out on. A lot of this is technology, but it's complete access as well. So e-filing is, as most of you know, we've had mandatory e-filing for lawyers for many years now. The appellate level has mandatory e-filing for self-represented parties and attorneys, but we do not have mandatory e-filing for self-represented parties at the trial court level. And there are, I think probably we could spend a meeting talking about the pluses and minuses of that, but just to give you kind of some perspective in terms of the number of self-represented parties that actually do e-file with us, and just some perspective. So before the pandemic hit, you were required, if you're a self-represented party, to verify your ID by going down to the courthouse physically, presenting your ID, having a notarized document, I am who I say I am, just to prevent, obviously, nefarious sort of activity. When the pandemic hit and we, all but, we limited our operations, we changed that process that self-represented parties could then apply for e-filing access electronically. They can do it by email and verify their ID by email, which, remarkably, we saw a giant spike, way up to, from 38% to 64% of self-represented parties asking for access. So there's two sort of competing pieces. There's asking for registering for e-services and asking for e-services access. And then there's the second piece of electronic access to your actual case. So we did see a spike with COVID, which again, hopefully the process is simpler, and then parties have wanted access to their case and they couldn't come in the courthouse. So that was great. But to give you some perspective in terms of how much more work we have to do to provide the marketing or just the incentive for self-reps to e-file. So the number I'll give you is currently. So we have just about a little over almost 440,000 self-represented appearances. I'm talking civil family now, e-filing, civil family cases on pending matters. I'm not talking post-judgment, talking pending civil and family actions, not including small claims, I would also offer, but including housing. So that's a lot. So so keep that number, it's like 435.9. So of that number, we're looking at now, we had about 1,200, almost 1,300 requests for self-represented parties to request access to e-services. Of that 1,290, 777 requested electronic access, either came down to their ID or did their ID, had it verified. So 777 actually got that e-filing access. That kind of gives you a perspective about, how much more work really we have to do in terms of making e-filing more attractive, having access to your case at night and off business, hours, being able to access your pleadings if you have an appearance on file, if you're a party or of record. So it's while we're making some progress, and obviously we have not, as a matter of access, made it mandatory for self-represented parties to e-file. However, we do feel like it is an access issue, and it is a positive one. It does have benefits. I say that, and then the competing piece of it is most people have one case. So, this is not the way they make a living, where they're going to be doing it over and over again as practitioners. They have one case, they have a divorce, they have a small claims matter, whatever the case may be. What is the incentive to go through that, when you're just going to be sort of one and done? So I can see both pieces of it, but from our perspective, from the branch's perspective, I think overall from litigants' perspectives, it really does make it easier to manage your case if you have electronic access and can, once the kids are in bed and supper is done and you can sit down at your computer and look at your case or file something. It's an interesting statistic. One I think we all hope will change as more self-reps start to e-file. So I wanted to pass that along. The other thing I wanted to, two other things quickly. So we talked about remote rooms. John talked about the public libraries having remote rooms. We still do, as you all know, we have 86 remote rooms statewide in judicial districts, GA, JDs, our juvenile courts statewide. We have remote rooms in lockup as well for, those folks who are in lockup have to meet with their public defender or bail or whatever. So we have those. They are utilized far more in our housing sessions, as you might expect, than in the regular JD GA courts. But they are, we do have them established still. They are getting used. As you know, probably also in mediations, parties can participate by phone. So we do have folks who have phones that can participate in their mediation via phone, so they don't necessarily have to come into the courthouse. But in addition to those 86 remote rooms, we also have these additional pods, kind of like Dawn talked about, that we purchased through COVID funding, that are like pop-up pods that, they're conversation booths, we call them, where parties can participate in a video session, team session by coming into the courthouse. So we are continuing to expand that level of access, looking through the lens of many parties don't have access to technology. So I think kudos to us for doing that and for continuing to expand it. So that's something I wanted to mention. And then relatedly, so we have, as many of you know, we have volunteer attorney programs that we've had now for a number of years, the first of which I think popped up in 2009 in Hartford Family, but we have 17 volunteer attorney programs now statewide that exist in 8 judicial district locations. So we have them in family, foreclosure, small claims, and regular Superior Court contract collections cases. They are, I mean, when Brendan and Berta were talking about, you know, the program that the homeless mediation program, it's great because that's pre-filing. Well, you know, we don't require a case to be pending for our programs either. And I have to tell you that is one of the things that I am proud of that we do. It's the acknowledgement that I'm not sure if I even, you know, want to file a divorce, or if I want to pursue or file an appearance and an answer in my small claims case. I need some information first. So it's nice that parties are not precluded from going down and getting that quick advice. You know, no income limitations, can go down into the courthouse. Well, historically they can, now it's remote, but I'll talk about that. But it's a very liberal structure for those programs, and I'm you know, pleased that they have continued to sustain themselves. We have a great pro bono pool of lawyers who participate. The lawyers are now all participating remotely from their respective offices. We are requiring self-represented parties that participate in the programs to actually come down to the courthouse, though, because it's a walk-in model, so advice session walk-in model. So there's no way to send a Teams link because they're not scheduled in advance. So if they walk into a courthouse, they can sit in one of our remote rooms. They can have that one-on-one advice session. It's going very well. You know, I think obviously it's going to take some time for that momentum to kick back in again, but they are going extremely well. So I wanted just to report on those. And Judge Pizzuto, anything that you think I may have left out?
No, Krista, thank you. You covered it all. Good job.
Thanks.
As always.
Thank you, Krista, and for that update. I think it's always very useful for us as the Access to Justice Commission to be aware of these programs going on. You know, part of the role of this umbrella agency is so that we all can share what we're doing, either collectively, obviously, but also independently. And I think it's important that we all know what's happening from the various members of this commission. I do want to, before I move on, to turn it over to Lauren for our next meeting, and before closing. We have about 25 minutes, so we're doing quite well. I do want to open up. I will end right at 4. I want to respect your time. If we end earlier, that's fine too. But before we do that, I know that Attorney Sexton was with us. I don't know if he's had to leave. I didn't see. And he co-chairs the appellate pro bono work group with Judge Bright and Judge Moll. And if he is with us, Attorney Sexton, if you'd like us to give us an update, you don't have to. Don't mean to put you on the spot, but want to give you a chance to do so if you wish.
No, absolutely, Your Honor, and thank you. Unfortunately, the report isn't that significant. We are in the process of putting some of the final touches on draft language that we have for a limited scope representation in the appellate context, which we think is probably going to be the first necessary step in order to effectuate some of the low bono, pro bono type opportunities for appellate representation. So we're hoping to have that certainly before the next Access to Justice Commission. The benefit of working with the Chief Judge of the Appellate Court and with Judge Moll, and also having Justice Khan as the chair of the Access to Justice Commission, is that we have pretty good access to getting the inside scoop on whether the Appellate Court judges and Supreme Court justices would be, amenable to the language we're suggesting. So hopefully we'll be able to vet some of that in the background before proposing language, sharing the language with the commission generally. But that's where we are right now, and we'll certainly have more to report, both in terms of the actual language we're working on, and then what we view as the next steps following the self-limited or the limited scope representations, moving forward.
Thank you, Attorney Sexton. Thank you for the report. And I know that you are a leader in the fact that you were one of the first to take on your firm pro bono appellate representation, and Attorney Sexton's right. I think I see him just about every week that we sit, or a member of his firm, as his law firm specializes in appellate advocacy. So thank you, and we look forward to the work of your work group. Before I turn it over to Lauren, I just want to, for our next meeting and before we end, I want to see first if there are any questions from anyone, any comments, anyone who had a concern, question about any of our presentations today, initiatives, ideas, proposals. Either raise your virtual hand or speak up. I'm not seeing any. Lauren and Alex. Oh, Jennifer. Yes, please. Jennifer Ferranti, who heads the incubator program in conjunction with Quinnipiac out of Bridgeport.
Oh, thank you, Justice Khan. I just wanted to briefly comment on Krista's presentation regarding the ability of self-reps to enroll in e-services. For many of our advice and counsel clients here at the center, that was really life-changing for them, very empowering to be able to stay on top of their cases and feel connected to their cases during the pandemic.
Thank you, Attorney Ferranti. I see Krista nodding. She doesn't very much take praise well, even though she does all of the work, but she does. She's one of those people that you definitely want on every committee that you're on, and I do thank her, and I thank you for acknowledging that, her amazing work. I don't see other hands up or questions. Please feel free to raise your hand or ask or add anything. There is one additional announcement that I just wanted to make, and that is that I am a co-chair with Judge Yuhas out of Los Angeles of the ABA Access to Justice Racial Justice Work Group. We meet every other month. We have presenters and thinking about ways in which our access to justice commissions nationwide can work on racial justice issues. If any of you have any ideas, I know some of you have joined some of our meetings. I know Krista, Judge Bizzuto, Ty have attended our meetings, our bi-monthly meetings. I do want to send a word out about another related organization, and that is Ted Howard, who works out of DC but is very active on the ABA, created what's called and is a member or chairs the Law Firm Anti-Racism Alliance. I don't know if you've heard of it, but it is a group of some of the top law firms in the country came together to see how law firms can work on anti-racism alliance and initiatives to promote racial justice and how they can work with the ABA and access to justice. Attorney Howard reached out to me and my co-chair and Shubi Diorius in our work group. They want to meet jointly with their acronym is LFAA, Law Firm Anti-Racism Alliance group, to see if there are ways in which we can suggest to them how they can be helpful. I say this to all of you, so whether it's in your respective work groups or the deans of the law schools, if there are things that you think law firms, this national organization can be assist, please let me know. I can get you in touch directly with Attorney Howard if you wish, or you can send me ideas and I'll certainly give credit where it is due. I would let them know that it is your idea. I will be sending him some suggestions, but if any of you have any, please let me know. I think that is all of the business that we have. We have two very brief items. One is our next meeting. I'm going to turn it over to Lauren, and then unless there are other questions or comments, close after that. Lauren.
All right, thank you, Justice Khan. So the next two possible meeting dates that we have are Thursday, March 10th, 2022, or Tuesday, March 15th, 2022. And the meeting would again be held remotely from 2 to 4 p.m. Though I'm not sure, given the number of members who are still here, would it make more sense to do another poll? Do you think? Okay, I know that worked well last time. So if you just want to make note that I'll send out an email with a poll with March 10th and March 15th as the possible dates, and we'll see what works best for most members.
Thank you, Lauren. Before we close and I entertain a motion to adjourn, again, I want to thank all of you for attending. I want to thank all of you who presented, who came up with these wonderful ideas of how we can continue to promote access to justice. For all your input and all of your work. I want to welcome our new members who we're very excited about. Look forward to a repeat presentation from our presenters about their very exciting, impactful work. And to the webinars and all of the initiatives, and Krista Hess leading us in the prioritization list and all of the other programs. So again, I can't thank all of you. A special thanks to Alex and Lauren, who, again, without them, none of this would happen. None of this would be coordinated, and we wouldn't accomplish what we have. So I can't thank you enough. Please keep in mind, they are not paid for this. They do this over and above their regular day jobs, like most of us, but they really have the lion's share of the work, and I thank them. I thank all of you for attending. I'm very excited. And please continue this collaboration and this work. Thank you for your time. We're mindful. We are ending 15 minutes early. I appreciate you giving us 2 hours every 3 months and then all the other work. Thank you so much.
Thank you.